So, without further ado, you'll find out who I am, not only from this, but in the course of this lecture. And I'd like to welcome you if you've come for the first time or if you've come back. Each of these lectures is relatively freestanding. There are links between them, of course, the theme and some cross-references, but if you weren't here for the first one, don't worry. This is not going to depend upon knowledge of the first. Okay, these are the topics I'll be covering in this lecture. In my first lecture last week, I introduced the history of identity and identification in general, and I explained the rationale for devoting my remaining lectures to the topics of the personal name, which is today's topic, handwriting and the signature, which you'll get to hear next week, and then finally the tattoo, all of them as identificatory signs or marks. Today, as I've said, my subject is the personal name, but I'm not going to be looking at it in its most usual ways, which is the genealogy conveyed in names, or the etymology, or the history of how personal names came into existence, although I'll touch on that. In keeping with the theme of the lectures, my subject is how the law and the state have treated personal names. And I hope to make that more interesting than it may sound at first sight. The question I want you to think about as I begin, is this. Is your name primarily a private concern for you, your parents, your friends, or is it a public matter, something in which the law and the state have a legitimate interest? This lecture is about the different ways in which this question has been answered in a number of countries, England, France, and Germany, which have rather different histories. And I'm going to be moving up a scale that will take us from the least interventionist to the most imperious regimes of regulation. And I'll end by showing you, through some examples, exactly how high the stakes in naming might become. If you were at my lecture last week, you'll remember meeting this character, Mrs. Chirk, on this doctored clothing book, a character in Nigel Dennis's 1955 novel Cards of Identity, which is a very funny story about the making and unmaking of identity. Mrs. Chirk, in this novel, is the luckless subject of an experimental project in the manufacture of identity, and she becomes unable to remember her name because she's forgotten who she is. Endowing her with a new name, because of her forgetfulness, the experimenters urge her not to lose her name again, or at least, as they say, quote, not to lose the ration book and identity card on which your name is written. The documents, which in other words will function not just as a ratification of her forgotten identity, but almost as the very source of it. Now, the way that the novelist Nigel Dennis sold us together name and identity is absolutely and totally on target. Personal names are the spontaneous and universal accompaniment to living in human society. I bet you all have names, and I bet they're known to the people around you. The connection between you and your name is intimate and intense, even if most of us owe this connection not to our own choice, but to our parents rather than ourselves. But even if our personal name is established only by ancestry, conferral, and repetition, it's still likely to bond us to our social and existential identity and our life in general with a power that few other mnemonic forms have. Research in the United States, I mean, this is now fairly old, 1980s, but I think it probably is still valid, its conclusions are still valid, indicated that the most frequent answer to the question, who are you, is to give your name. Admittedly, the frequency with which that was the major identifier declined as people moved into adulthood and other identities accumulated. But research on traumatic amnesia has also concluded in the same vein that, quote, the name is a kind of monogram for the sum total of a person's memories of affective significance. Now, I can vouch for this status of the personal name by personal experience, and I expect many of you have had the same kind of feeling in similar circumstances. When I applied for American citizenship many years ago, I was offered the opportunity to change my name, a choice that, of course, many immigrants make in order to anglicize foreign names. That's the usual reason. In my case, I was tempted to take the chance to officially abolish the first of my given names, which is Amanda. I've never used the name, and its existence causes me all kinds of minor irritations. But my hand, as it hovered over the relevant section of the form, couldn't quite bring me to abolish this name, to change my name. I couldn't really defeat a sense that I'd be betraying my parents, who'd bothered to give me 2 names at birth, even though they never bothered to use the first one after that. An act of perversity, which, as I say, has been rather annoying. So I succumbed to a kind of access of filial sentimentality that overrode my completely rational feeling that it was time to just revert to being Jane Caplan, which is what I think of myself as. But I left my names as they were. Now, I've just said that I never use my first name, but of course I do, because it's on most of the official documents that are issued to me, starting with my birth certificate. That's the origin of my name, or the origin of its registration. So my birth certificate and anything dependent on my birth certificate, like a passport, a national insurance number, or indeed my driving license, bears both of my names. Over the years, I've more or less come to recognize myself as Amanda when I'm summoned into the GP's surgery, or I'm called upon to exercise my democratic rights as a voter in 2 countries. But my full given names are in fact not on all of the identity documents that I use. And when I checked them when I was writing this lecture, I couldn't always see the reason behind which name is where. Okay, so this is me in various guises. Okay, these are various current identity documents. You have me nailed here. For example, my United States Social Security card, which is this one, knows me more parsimoniously than my US passport, which I haven't shown on this. Both my US and UK driver's licenses, which are, I think I've only got this is my US, my Pennsylvania driver's license, but the same with my British driving license. They know that I'm Amanda Jane Caplan, but if I travel by bus using my pensioner's pass, I'm just plain Jane. Okay, Oxford University, up here, thinks that I'm a Jane Caplan, which sometimes lead me to suppose that I'm just one of many Jane Caplans at Oxford, but I'm certainly not the Jane Caplan. At one point, when I was living in the United States, I had to appear before a notary public, a character who's going to appear in my next lecture, or just the general field of notary work will appear next week too. But the notary public had to accept my oath that I was the same person. Jane Caplan was Amanda Jane Caplan, and both of them were me. And there you have the affidavit. I think I was applying for a mortgage or something at the time. That's why it's the bank that wanted to know. Ironically, while I was writing this lecture, literally at the very point when I was doing this, I was in turmoil trying to persuade Marks and Spencer that they would accept that Jane Caplan, who just applied for a credit card with them, was the same person as Amanda Jane Caplan, who's recorded at my address on the electoral register, but who somehow, between Amanda Jane on the register and Jane who'd applied for the credit card, there was a slippage which Marks and Spencer couldn't deal with. Well, we finally sorted it out. Well, I could go on, but you get the picture. Perhaps I'm more like the luckless Mrs. Chirk than I would like to recognise. I live in a world of nominal confusion, in other words, and maybe some of you do too. Now, if we do live in this world of nominal unclarity, it's only because we live in England, where the law does not regulate our personal names. And I'm not going to be speaking today about the legal protection of trade names, which is an entirely different matter. Under the rule of common law, and that also operates in the United States and some other ex-colonial countries, what counts to stabilise your name is what's called use and reputation. You can call yourself by any name you like, and you can change your name at will in this country, but with the proviso that you must establish that this is in fact how you are known to the people you come into contact with. The only restriction is that you must not be intending to use a new name for fraudulent purposes, for example, to evade a debt or to contract a bigamous marriage. Your forenames are either conferred by baptism as Christian names or by someone, usually a parent, who gives you that name. Your surname is, quote, there are going to be a lot of quotes from legal judgments in the next couple of lectures, is, quote, merely the name by which a person is generally known. That's Mr. Justice Ormrod in 1979. Now, the regulations about the registration of births, perhaps I wouldn't say, looking at my audience, that people have done this recently, but they certainly have registered births, These regulations include many stipulations about procedures for registering a newborn's name, but in law, going along to the register office and registering a name doesn't confer the name. Okay? It is not an act of conferral, it is an act of registration, which merely establishes or commences what is known as a repute. Once you're of legal age, then, it's up to you whether or not you want to stick with your registered names. A representative legal judgment put it this way in 1865, and there are a lot of 19th century legal cases that I find very useful. In fact, people who write on these subjects generally find useful, because the 19th century is the period when case law established a range of practices which remain still prevailing, as we will see also next week. So in 1865, the court held that, quote, if a man has a name which displeases him, there is nothing in law to prevent his changing it to any other he likes better, provided he can get the public to adopt and use the name he prefers. So that's the regulation about, or the convention of use and reputation. A more recent legal text put it this way, quote, what an individual's name is at any particular time is a matter of fact rather than a matter of law. That's the distinction. The state, in other words, has virtually nothing to do with the matter, other than to be satisfied on occasion that there is evidence that a change of name has taken place. But as I say, that is almost always a fact of law. A fact of fact. It's an issue of fact, not an issue of law. I can nuance the matter a bit by saying that there is a distinction of kinds between forenames and surnames. As one 19th century commentator on the subject put it crisply, quote, the law of surnames may be concisely stated, there is none at all. The situation with the forename is a bit more ambiguous, because a Christian name that's given by a Church of England baptism is an act of conferral, and in principle it can't be changed without the permission of the bishop. I think that the parish register of baptismal names cannot be altered, but this is also basically true of the civil register. It's hard to get the civil register changed in this way. There are limited provisions for re-registering the name of a child within 12 months of a registered birth. If you change your mind, you can go back and say, I don't like Anne, I want to call her Elizabeth, or whatever. There are also changes of name that take place on adoption and in some other circumstances which can be re-registered. But otherwise, even if you assume a new name as an adult, your birth registration and birth certificate will remain in your original but now discarded name. I think the only exception here is under the Gender Recognition Act of 2004, which allows officially certified transsexual persons, and there's a process for registering transsexuality. Once you're registered, you can re-record your newly acquired gender and name in a new register called the Gender Recognition Register. This is a very interesting register. Unlike the register of births, or the registers of births, marriages, and deaths, the Gender Recognition Register is not open for inspection, or at least not open to public inspection. This doesn't mean, however, the situation I've been describing, that there are no legal instruments to fortify the evidence that you've assumed a new name. And that's useful, for example, if you do want to apply for a passport in a new name. There are several such instruments. They include the kind of notarial declaration that I made in America, royal license, and Act of Parliament. These last three are very uncommon. The most usual method is the deed poll, and a deed poll is a term simply that means a deed that's made and executed by a single party. At one time, you could also place an announcement in the Times, as we will see shortly. I don't know if that's still the case, I doubt it. The deed poll became the method of choice from the 19th century, with the other methods usually being confined to cases where wills, property, and coats of arms were involved. And there are an awful lot of those in the 19th century, or at least, I mean, they seem quite numerous to me, of people who in order to receive a legacy, had to change their name to, it was often in order to allow a name of a family not to die out, and that they would leave money to somebody on condition that they change their name from X to Y. And sometimes this also involved registering yourself at the College of Heralds for a coat of arms, or registering your right to bear a coat of arms. There was a celebrated case in the 1860s which raised doubts about whether the assumption of a new personal name also founded a right to require it to be used and recognised by every third party. And I think that's what helped to prompt this push to register your name. The debate over this question of whether you could actually insist that people used your new name was quite humorous at times. And I think actually that humour seems to be the main register in which the English have discussed the question of personal names, against rather more solemn discussions of it elsewhere. There was, of course, quite a serious debate about this in the mid-19th century, but one of the contributors to this debate, who took it more lightly, raised a populist cry in 1862 in a pamphlet he wrote, and I quote from it. "Are labourers not to have the names of distinguished families? Are country esquires to be forbidden to assume the names of labourers or tradesmen? Are offensive names not to be got rid of without great cost or expense? Is Mr. Bridecake not to change his name to Brideoak? Is Mr. Shufflebottom to be content with the unrelenting ridicule which his name suggests? Is Mr. Hogflesh not to become Mr. Hoffleash? And is Mr. Bug or Mr. Humbug, with fortune, influence and talent, to be laughed off the hustings?" That reference to Mr. Bug would have resonated, I think, with readers of this pamphlet, because shortly before its publication, a practical joker had inserted a spoof small ad into the Thames under the name of Norfolk Howard late Joshua Bug, declaring that he was renouncing the name Bug and was to be known in future as Norfolk Howard, of course a rather famous ducal family name. And that occasioned lots of jokes about, the number of bugs that were to be found in Bedfordshire and so on. British or English, and this really is a case where we're talking about English national law, but as it was applied elsewhere in the United Kingdom, it remained largely uninterested in our names, and this was true even in times of national crisis. I mentioned last week the introduction of the National Register in 1939, and when it was enforced between 1939 and 1952, a British citizen was nevertheless entitled to change his or her name by advance declaration to the General Register Office and by publication in one of the official gazettes. And thereupon, they could receive a new identity card and a ration book. And I actually don't know how often this took place. I mean, presumably, a married woman, a woman on marriage, when it was normal to change a woman's name to her husband's name, there would be provision for that. I don't know whether people during the war changed their names for other reasons too and were able to take advantage of this procedure. I presume they were legally entitled to, but how often that happened, I don't know. The greatest restraint in England on the changing of your personal name was introduced in the First World War in 1916, when enemy aliens were required to be registered and were forbidden to change their names. And in 1919, this was extended not just it was extended from enemy aliens to all aliens who were required to continue with the name that they'd held on the 4th of August 1914, in other words, just as hostilities broke out. Exemptions were only allowed by permission of the Home Secretary, and these provisions were not repealed until 1971. It's quite characteristic that aliens are put under much more onerous conditions than citizens, and that procedure that I've just mentioned, in which you had to make an application to change your name to the Home Secretary, gestures towards the kind of regulation that we'll be meeting in a moment. Now, this otherwise rather lax state of affairs did not please everybody. Towards the end of the 18th century, that great rationaliser, Jeremy Bentham, deplored what he called the nominal confusion that prevailed in England. "It is to be regretted," he wrote, "that the proper names of individuals are on so irregular a footing that they only imperfectly accomplish their object in a great nation." He therefore suggested the utility of what he called a new nomenclature, so arranged that in a whole nation, every individual should have a proper name which should belong to him alone, and therefore not be like anyone else's. This rationalised system of legal nomenclature would consist of a family name, a single baptismal or forename, no point in wasting more than one on anybody, and your place and date of birth. Bentham also had some unusual suggestions about how to record this information, which we will meet in my final lecture. Well, Bentham, I think, may have intended this proposal as slightly tongue-in-cheek. It's sometimes a little difficult to tell with him, since he was responsible for many wild and outrageous and entertaining schemes to rationalize life. And it may seem bizarre to us in this country, the idea of having a rational nomenclature. But it might not appear quite so far-fetched in some other national contexts. Historically, more countries, at least more countries in Europe, have adopted some kind of state regulation of the personal name than have left them to run free as they do in this country. If we turn our sights to continental Europe, we'll find a rather different nominal landscape from what we find here. As I indicated at the start of this lecture, personal names are predominantly a social institution, or preeminently a social institution. They often denote not just individual and family identities, but social distinctions, property relations, and so on. The history of the personal name in post-Roman Europe therefore begins as a social history, and there's a whole sense in which it remains a social history. The history of personal names is a history of how societies organize themselves, of cultures, and so on. It's not a legal history predominantly. Broadly, it's the history of how the two-part name, forename and surname, came to become the European standard, a process which proceeded very slowly, and it took place in advance of any enactments by the state. Of course, this aspect, the social and etymological history of names and naming, is much more intricate than I've indicated, and it's utterly fascinating, but it won't fascinate us here today, I'm afraid, because, as I've said, it's not my subject today. What does concern me now is what I call the history of the legal seizure of the personal name, the processes through which the law and the state arrogated to themselves in certain countries the right to insist that fixed personal names be registered and used in all transactions between citizens and public authorities. When continental European states did begin to address this issue, roughly from about the 17th century, their policies transformed social stabilization, or the social history of the name, into legal immutability. And these processes, of course, went hand in hand with the accelerating pressures to register and prove identity that I spoke about in my first lecture. And also with this a very big question of the transition from an oral to a written documentary culture, which in some ways runs through these lectures and which I'll revert to next week as well. I think France was the pioneer here. A slow accretion of procedural and police rulings carried the work of stabilizing the name, the individual name, in modern France. But the first specific legislation that forbade citizens to bear any other names than those conferred at their birth was not enacted until revolutionary France in the 1790s. And again, as you can see, I mean, this is more or less the same time that Bentham was making his proposals in England. And both Bentham and the French Revolution are heirs to an Enlightenment moment of trying to figure out how all kinds of things, government, society, and so on, could be put on a reformed and rational basis. The French legislation of the revolutionary period was prompted by the attack on aristocratic titles and the chaos of renaming that was introduced by the revolution. Upheavals, political upheavals, often have a tremendous effect on names and naming conventions. In the revolution, what was happening was that parents would want to have their child baptized in newly fashionable names or names borrowed from a bigger vocabulary, such as liberté, Brutus, or Marat. These are all examples. A man named Le Roi might decide that his name was now a political embarrassment and want to change it perhaps to citoyen or something like that. The French regime, the revolutionary new regime of control over names that was enacted in the 1790s was confirmed in the Napoleonic period by restrictive legislation in the early 19th century, which remained the basis of French name law until the reforms of 1993. So this is really almost 200 years of fairly intrusive regulation. Among other provisions, these laws forbade the adoption or use of any fore or surname other than those that had been registered at birth, in other words, that were in the registration books kept at the local mairie. Anyone who had changed their name since the revolution was supposed to revert to their original name to smoke out disguised aristocrats and so on. The stock of permitted forenames was restricted to calendrical and historical names, in other words, saints' names and names that had some claim to be historical names. And to be valid, finally, all legal and public documents must refer to individuals by their full registered name alone. At a stroke, therefore, your registered name became your immutable legal or public name, a completely different situation from this country. In theory, changes of name could be licensed, and of course there are cases of that in the 19th century. There was a procedure for doing so, but it was arduous, it was restrictive, it was lengthy, and it took place rarely. Now, it has to be said that, of course, this new political regime did not always overrule people's real lives. I mean, it ran parallel with the real lives in which social conventions continued, and family tradition and so on continued to have their own effect independently on the names by which people were known. Your civil name, in other words, might have to be stabilized for transactions with the state, including education, conscription, voting, and so on. But your private name was likely to continue to obey all manner of local usages and variations, which proceeded blithely to identify you in every other circumstance. In France, for example, social custom included the practice of changing your forename at major life stages, so in some respects emulating, if you like, the adoption of the husband's name by the wife, but your forename might be changed as your life moved on. You might use different names in different social circles, and this was unaffected by whatever the law said. An anthropologist who investigated the matter in a somewhat remote rural area of France in the 1970s reported one respondent as saying, quote, "I give my children one name at the mayor's office and then some other ones at the church." From another informant came the statement that, quote, "Yeah, in our family there was Louis, known as Georges, and then there was Marguerite, whose real name was Jeanne." And there were lots of examples like this, and it went on up to the cemetery, to death, where in the cemetery you could find a tombstone that read, quote, "On the 20th of November died Émile Lucien Albert Frédéric, known as Jean Camusset," thus showing that custom is resilient to politics, or resistant to politics even after death. Now, with Napoleon's introduction of French law into western regions of Germany in 1806, parts of the Rhineland, which were briefly under French rule in effect, and some other German regions also began to follow the French lead on the law of names. Hitherto, German practice had on the whole followed the principles of common law, so the same kinds of principles as in England. The state was understood in this pre-Napoleonic period in Germany to have no interest in a person's name, but would treat it as a natural right that was left to your own discretion to choose and to public consensus to underwrite, so much the same as in England. But in the early 19th century, this position was slipping into its opposite, under the impact not only of the influence of French law, but also of autonomous changes in the character and reach of German state systems. These are these huge transformations which historians have to learn to sort of encapsulate in some ways in a few pithy summaries, but you could characterize this as the 19th century transformation of enlightened despotism in these areas into the modern interventionist state. That's one way of putting it. Enlightened despotism in the late 18th century, the modern interventionist state as one of its possible transformed forms by the late 19th century. And that state, of course, had generated a growing number of relationships and transactions in which a documented individual identity was a prerequisite. Taxation, education, conscription, voting, and so on. I talked a bit about this in my first lecture, this sort of large secular change in the structure and reach of the state in the 19th century. So I'm going to cut a long story short and just say that unified Germany in the late 19th century adopted a nationwide civil registration law in 1875. In other words, the kind of law that had been adopted in England in the 1830s, 1840s. And the German law enforced civil registration nationally for the first time. There had been civil registration introduced in some of the German states that in 1871 became the unified Germany. But this was the first national law, and it established a network of national registration districts and offices, the Standesämter, as they were called, throughout the whole of Germany. So that's the sort of umbrella system. And then within that, each of the German states that were members of the German Empire issued its own regulations, more specifically, on how names were to be regulated. A number of states restricted the choice of forename to those that were customary. And so, for example, the name Jesus was deemed unacceptable. And this was usually in the hands of the local register office. You'd go along and say, I want to call my child Jesus, and they'd say the German equivalent of no way. Names that were, a number of names, you get this all the way along, actually, in the history of naming. So in Germany, names like Bebelin and Lassaline, which were drawn from, those are sort of feminized versions of the names Bebel and Lassalle, who were leaders of the German social democratic movement in the second half of the 19th century. So politically conscious social democrats might want to confer on their child the name Bebelin or Lassaline as a gesture of honor to their great leaders. And of course, this happened again in Soviet Russia. It happens time and again that names are formed for to honor and to commemorate major political leaders. Well, they were told they couldn't use those names. Other states, and this has got shades of Bentham, I think, tried to ensure that the registered name of a newborn child should not be identical to that of any other local inhabitant. Okay, now that may sound, that's got, as I said, an air of Benthamite rationalization about it. But of course, it's deeply intrusive to cultures whose naming practices honored parents and grandparents. It could be thought to be extremely intrusive. German states also imposed tougher regulation on the procedure for changes of name. By the end of the 19th century, after these processes I've been talking about, German citizens no longer possessed any residual rights to change their name at will. On the contrary, they were placed under a legal obligation by the terms of the Penal Code to use their full and correct name in all transactions with the state, again, like France. By the early 20th century, one of the legal authorities on this area of law, Namensrecht, name law, could summarize the situation like this. Quote, and just think how different this is, the tone of this is from my initial description of the situation in this country. So, this quotation, "The great interest that the public administration has in the reliable designation of every individual and in his differentiation from others entails that the regulation of name matters will proceed according to public law principles and by means of fixed rules. The right to choose or change one's family name is therefore no longer a matter of individual discretion, and while the forename may be freely chosen, the individual is not empowered to change it at will." So in the way that German public and private law are distinguished from each other, you had private law rights. There was at the same time in the German Civil Code some forms of protection for the personal name from its misuse by others, although that area of law is quite complicated. But there's also this public law, the declaration of public law interests in your name, and that the state and the community that the state supposedly serves or organizes has a legitimate interest in stabilizing your name and making you knowable under that name. So there you have it. It's the opposite of the situation we live under in this country. Well, what's protected Britain from this outcome? If Britain is unusual in this situation, why should it have had such a different history? The short answer, I think, is that it resulted from the totally different trajectories or the distinguishable trajectories of the three political cultures I've been discussing, English, later British, political culture, French and German, which produced three different versions of the liberal state in the 19th century. At the risk of selectivity and simplification, let me try and pick out three elements of this. First, the foundations of a centralized bureaucratic and interventionist state were laid in France by its absolutist monarchs from the 16th century, and in Germany by Prussian and some other princes in the 18th century. Neither of these developments, which you can spot analogues to this. In Britain, for example, there was at one point in history a long debate about the extent to which you could call Henry VIII an absolutist monarch on the French model or advancing towards that. Again, debates about the character of the 17th century monarchy in Britain in England before it was overthrown. But in England, these tendencies towards absolutism, centralization, and bureaucratization were balanced by a countervailing parliamentarism that was absent from, or relatively less prominent in France and in Germany. You can hear me qualifying this every time I make an apodictic statement of this kind. I want to say, well, it's a little more complicated than that. But this will, I think, pick up the main themes of the difference that I'm trying to talk about. England had a history of the defence, at least to some extent, of popular liberties against the monarch and then the state. I mean, perhaps we should ask Mr. Cameron to think about that history when he's thinking about the history of Magna Carta and the history of British values. Secondly, the significance of the French Revolution in promoting new concepts of law and citizenship, which balanced and codified obligations and duties, cannot be overestimated. While 19th century German states didn't share exactly the same principles, the effect of unification was comparable in prompting the codification of German law, in producing new constructs of civil identity and new understandings of the relationship between the individual and community. And I think in this connection, this short-lived but very deeply penetrating French occupation and reorganization of the Rhineland also had ongoing influence in the history of 19th century Germany. Finally, in both the French and German processes of legal codification, jurists and constitutionalists continue to draw more directly from the formal principles of Roman law than the historical traditions of common law, again by contrast with the development of English law. Again, this is a complicated issue because Germany had a strong common law tradition. Britain certainly has not turned its back on codified, on Roman law and the Byzantine codes, but relatively speaking, common law has sustained a much greater role, or at least in the period that I'm talking about, the 19th century, than it did in the German and French states. So continental Europe's restrictive laws on personal names were, in a manner of speaking, collateral damage in these large-scale movements of political and legal change. Now, I want to stick with Germany for the final part of my lecture. In the case of Germany, there was a further impulse at work, which was also present in France, but not, I think, quite as prominently. Let me explain. I think it's safe to say that the majority of French and Germans have not, in fact, had their lives irredeemably blighted by being forced to live under these restrictive systems of name law for the past 200 years. I mean, there are occasional cases, and they used to be more prominent in the up until liberalizations of the law in recent years, where furious parents found that they could not register the name of their child as they wanted it to, and they fought the cases right up to the various high levels of the administration. But on the whole, I don't think that being obliged to have your name registered and fixed at birth was thought as the mark of a tyranny. At the same time, however, significant minorities in both France and Germany, as well as in many other countries, have indeed suffered indignity and discrimination as a result of the state's power to regulate their names. Two of the arenas in which this kind of discriminatory legislation has typically taken place are the imposition of fixed surnames on groups that don't traditionally use them, and forcible changes of name imposed on ethnically or linguistically distinctive populations acquired by conquest or colonization. Among numerous examples of this, we could cite the French government's requirement in 1882 that Algerian heads of households must adopt patronymic names or have those names forced upon them. And that, actually, not incidentally, accompanied the first issue of compulsory identity cards in French territories. Similarly, in the interwar period, I mean, these are examples chosen, not exactly at random, but they're chosen from many, many possible examples. In the interwar period, the Italian fascist government insisted on the forcible italicization of German and Slav names in South Tyrol and Trieste, while in the 1980s, to come slightly further up to date, Bulgarians with Turkish names were forced to apply to Bulgaricize their names. I don't know if that's a word, but anyway, to convert their Turkish names to Bulgarian versions of the same thing, and one could expand that list. One of the most widespread and long-lasting projects for the imposition of names on the ostensibly nameless, what the state regarded as the insufficiently named, let's put it that way, in modern Europe was the requirement that Jews must adopt fixed surnames in place of their non-heritable patronymics. This was typically pursued in the name of emancipation. And in fact, if you look at Germany, Jews who, particularly enlightened community of Jews there in the 18th century, who were voluntarily assuming fixed and heritable surnames long before the law got involved in it. The first such decree was issued by the enlightened Habsburg ruler, Joseph II, in 1787, obliging the Jews to to choose fixed and heritable surnames. In France, Jews had been granted citizenship by the revolutionary government in 1791, and in 1808, they were required to register fixed surnames as well as forenames under rules intended to assimilate them to the general population. And that, of course, is the problem of emancipation. Emancipation and forced assimilation are sort of two sides of the same coin. For French Jews, names that were drawn from the Old Testament or from their places of residence were in principle barred. In Germany, Prussia was the first state to issue similar regulations in 1812, and thereafter, the history of the legal regulation of personal names in Prussia, in other German states, and in Imperial Germany, unified Imperial Germany, was entangled in the complexities of Jewish emancipation on the one hand and anti-Semitism on the other hand. I think it's no exaggeration to say that one of the principal drivers of name law in 19th century Germany was, in fact, the desire on the part of government officials, as well as non-Jewish Germans, to ensure that their Jewish fellow citizens remained identifiable as Jews as they entered civil society on equal terms. The cost of emancipation was that instead of there had to be other markers. There had to be markers that showed you were Jewish, as far as anti-Semitic ideas shared both by members of the bureaucracy and by other Germans at large were concerned. Between the 1840s and the end of the 19th century, restrictions on change of name in Germany became tighter and more rigid, largely to control the ability of Jews to adopt in inverted commas, non-Jewish names. This story makes grim reading. It's full of grim ironies. Its sources lay in, as I've suggested, in the fundamental dilemmas of emancipation and assimilation for both Jews and anti-Semites. A Jew with a Jewish-sounding name in 19th century Germany was immediately identifiable as such and vulnerable to anti-Semitism. But Jews who applied to change a name that identified them as Jewish, whether it was a forename or a surname, were told speciously by the authorities that there was nothing dishonourable about being identifiable as a Jew. Now, and that they should get lost, basically, that if your name, if you were Itzhak Jakobson or whatever, that wasn't a problem. Why should a Jew be ashamed of being identifiable as a Jew? But of course, people in that situation often knew precisely why it was difficult for them to bear that kind of name. If a Jew did assume a not obviously Jewish name, he could be accused of being ashamed of his real identity or even of trying to conceal it, perhaps for nefarious purposes. He might even be taken to law by some outraged Christian for usurping and besmirching his own family name. Those cases were not, in fact, successful, but the fact that they were launched gives one some sense of the atmosphere within which this policy was enacted. Of course, in principle, the same restrictive laws applied to non-Jewish Germans as well, but in practice, their application was much tougher for Jews than for non-Jews. Non-Jewish Germans, if you were a non-Jewish German who had a Jewish-sounding name and wanted to change it to something less stigmatizing, you were more likely to get the necessary permissions than if you were Jewish. The liberal governments of the Weimar Republic after 1919 brought some amelioration to this official regime, but they were unable to resist the pressures of anti-Semitism, or they failed to do so with sufficient energy to change the underlying discourse, which is, and this is the thread of anti-Semitism in this period of modern anti-Semitism, Jews are disguising their identity as part of their plot to subvert Christian, or in this case specifically German, society. When the radically anti-Semitic National Socialist regime, the Nazis, seized power in Germany in 1933, it was committed not only to clarifying and policing this boundary between Jews and non-Jews, but making it the very principle of its vision of a new people's community, a cohesive, the German term is Volksgemeinschaft, a cohesive people's community based on the exclusion of those who didn't belong, for Aryans alone and for the right kind of Aryans only. It was obviously integral to this project that Jews could be identified as such, and that they were eventually able to be segregated, restricted, and in other ways corralled into a visible Jewish identity pending whatever the final solution of the Jewish question was to become. And of course, I'm not saying that this concept of what we now call the final solution, that term was in circulation in Germany, of course, in the 1930s, but what it actually embodied was not to become clear until the 1940s. Now, the most notorious of the Nazi state's new systems of discriminatory classification are undoubtedly the Nuremberg laws issued in 1935. These were the laws that framed racial classification and that banned intermarriage between Jewish and non-Jewish Germans. But the personal name played, I think, an important and much less widely recognized role in defining and publicizing who was and was not Jewish. It's the history of name law that I've described up to this point that allows us to understand that the Nazi government was not doing something unprecedented. I mean, in many ways, this is a key thing to think about in Nazi Germany. In my other incarnation, so to speak, Amanda Jane Caplan, or Jane Caplan, is a historian of Nazi Germany. And it's very important to think about the extent to which what was happening in Nazi Germany drew on much older or much more widespread attitudes and principles. In name law too, then, the Nazi government was drawing on an older and quite deep-seated current of juridical and political activity, and bringing them, if you like, to a conclusion of terrible logic. Having defined in 1935 who was Jewish by law, the Nazi government in August 1938 intensified this regime by promulgating new regulations that restricted Jews to a list of so-called Jewish forenames. I'm sure this is quite widely known. This was part of a general tightening up of name law under National Socialism, and it was also a preparation for issuing compulsory identity cards to Jews the following year. Any Jew who did not already bear one of this restrictive list of Jewish names was compelled to insert the boilerplate Jewish name Zara for women, or Israel for men, into their registered names. This is probably very, very difficult to read from this distance, but if you can see it, you will be able to see that this list of officially acceptable Jewish names, this is only part of the list, it's from one page, the male names are on the top, and then the beginning of the list of female names are underneath. These were deliberately taken from Polish Yiddish name stock, although it also included some Old Testament names in wider use, and I'll be talking about that in a moment. And this kind of older Polish Yiddish name was utterly alien to many in the largely assimilated German Jewish population. Let's have a look here. I mean, here, these sorts of names, Abel, Abiezer, Abimelech, Abner, Absalom, Ahab, Ahaziah, and so on. These Sabbatai, Zachar, these are not common names among assimilated German Jews. They would have been much more common among the more recent immigrants into Germany from what were, after 1919, the territories of Poland. But of course, those were precisely the names that many German Jews of Polish extraction, or who had been brought up born in Polish Yiddish-speaking territory, wanted to be shot of when they got into Germany. So it was the case that most German Jews had to adopt the additional compulsory names, the so-called Zwangsnamen, of Zara or Israel, into their full registered civil name, okay? And these were written into the civil status registers to produce a corrected version of the individual's full legal name. All official documents were now issued in these newly Judaized names, notably the new identity document, the Kennkarta, which Jews were now required to apply for. In a further provision, new surnames that had been approved before 1933, in other words, people had made applications and had their applications to change their surnames approved by the government, especially after 1919, but some of them before that date. But those names could be withdrawn, those re-registered names, change names, could be withdrawn if, as the law said, the name change is not seen as desirable. In other words, if it tended to disguise a person's Jewish origins. This power in the law was adopted solely in order to force Jews to abrogate recently adopted surnames which appeared to disguise their Jewish identity. Now, I think, and this is another sort of hobby horse of mine, that we shouldn't judge the effects of these new regulations merely by the standard that we know that far worse was to come for most of the Jews involved. Each application for a name correction or for a rectification of the records required for a marriage license represented a felt injury by the person concerned. For every Jew who had to go along and re-register their name, no longer as Jane Caplan, but as Jane Zara Caplan or whatever, was a huge, I think, a huge dishonour to the person concerned. And we shouldn't minimize, I think, the extent to which this was felt as an intrusive dishonour. The personal correspondence that you can find in the archives is replete with bewilderment and distress expressed by individuals concerned, whose lives and assumptions were being thrown out of kilter by these invasions of identity. Now, it's true that by 1938, many awful things had happened already in Germany. Yet, as I've argued earlier on, your name is very much part of your identity, and your sense that you want your name to reflect who you are, or even if you change it, that is your right to do, to change it, okay, if it accords with your identity. To have somebody else come along and say, no, this is how you have to be called in future, I think is a painful thing to happen. And I'd like to end now by offering 3 brief examples of what I mean. Let me first cite the case of Dora Lux. It's hard to know how many Jews refused to comply with the 1938 law on name registration. I guess not very many. But one of them was a woman called Dora Lux, a feisty Berlin schoolteacher of secular Jewish background, who simply declined to turn up to the register office in 1938. Her daughter later reported her mother as saying, quote, "I'm not going to put the noose around my neck just because they've told me to. I am not Jewish and my name isn't Zara. Let them come and get me." And it's true that she, I think, was baptized. She was certainly in that she was eventually married to a Christian. She had a family background that was both Christian and Jewish. In due course, though, this simple initial act to refuse a rewriting of her identity through her name was the essential step that protected this woman from the ultimately disastrous consequences of recognition and registration as a Jew. She never applied for the Jewish identity card, the Jewish Kennkarta. She simply slipped under the official radar. By a combination of ingenuity and pluck, and of course the help of her family members, she survived the war without ever going into hiding. And this is by huge contrast, I think, with an aunt of hers, not a sister, but a couple of other family members women who elected to go along and, like most of Berlin's or Germany's Jews, and register their new names or accept their new names. These other family members perished. But Dora Lux's initial act of refusing her new name protected her from the accelerating processes that were capturing and recording the identity and location of Germany's Jews, and that within a few years had marked them out for certain destruction. My second example concerns the members of the Götze family, who in 1938 were ordered to revert to their allegedly original surname of Schmuel, S-C-H-M-U-L. I probably should have made a slide with these names on it to help you to recognize them, but anyway. This change of name from Schmuel to Götze had taken place in Bromberg in 1893, when the surname Götze was originally registered by a family consisting of 2 parents and 10 children. By 1938 and 39, when the authorities initiated proceedings requiring the family to revert to the name of Schmuel, several of the surviving family members and their spouses were in their 80s and had lived under the name of Götze for many years. One of these 80-year-olds, Johanna Zara Götze, to give her newly registered name, declared to the authorities in March 1939 that, quote, "I will not take the family name Schmuel because the forebears of my husband were not called Schmuel but Götze. My husband's grandfather was named Samuel, otherwise known as Shmuel Götze, and his children were known as Shmuel's children." And I should explain here that Shmuel is a common nickname for the name Samuel, and the designation Shmuel's children is, if you like, a residue of the Jewish tradition of patronymic naming. So to say that somebody, for the children to be known as Shmuel's children is like saying they're known as Sam's children. Okay, and it's not that Sam is the surname, it's that that's the nickname and that's how the kids are known. Johanna then went on to explain that the name Schmuel had been recorded in error as a surname when one of the family members registered for military service. And when it was corrected, the rest of the family took this as the occasion to have their name properly registered as Götze. So she's arguing that there's a legal path. There's both an internal family story that explains the confusion, and there was a legal path by which they had registered their name as Götze. The recording of Schmuel, therefore, was a mistake, and the registered change of Johanna's husband's name in 1893, as she said, only corrected his name. It didn't originate it. She went on, "I reject the name of Schmuel. I have no need to bear a name that is not my own. In this large extended family, another relative, Samuel Götze, protested that he was authorized to use his surname and had done so for 46 years. Now in his 76th year, at the time when his case reached the Interior Ministry, he pointed out that he had no children, was the last of this family line, and living in an old people's home where he wrote, "As a result of my failing eyesight, I can neither read nor write. I cannot sign my name." This letter was in fact handwritten and signed, somewhat in contradiction to his claims. But when I came across this in the archives some years ago, I have to say I almost wept to see such a poignant testimony of the resistance of these elderly people to the Nazi state's incursion into what was left of their nominative identity. He couldn't read and he couldn't write. He said, my name is, he's not going to use his name very much longer. He's very old. Why should he have to change it according to the state's whims? Okay, my final example then takes up the question of identity from the perspective of a non-Jewish German who fought back against the arrogations of the state and whose story has been made the subject of a wonderful book by the German lawyer Winfried Seibert. This was a Westphalian pastor, Friedrich Lunker, who fought a determined, although in the 40s I should say, unsuccessful court battle to entitle him to register his daughter, who'd been born in August 1938, under the name of Esther. The Registrar of Births had declined to register the name Esther on the grounds that, quote, it was a typically Jewish name. The pastor refused to accept this lying down. Even though Esther is not among this list of names here, of Jewish names, the final court of appeal declared that the name violated the simultaneous provision that German citizens should in principle bear only German names, even though no official list of German names was ever issued. There's a reason behind that, which I won't go into here, but no official list of names saying these are German names. This was never listed. Only the names that were not German were listed. Or the names of Jews, let me correct myself. Although the new legislation allowed for exceptions where names had become effectively Germanized through long use, the court decided that the name of Esther could not be allowed through this loophole. The court's ruling in this case invoked an extraordinary discussion of the Old Testament story of Esther, designed to show that the name was indissolubly entangled with Esther's status as what the court described as a criminal prostitute of Jewish race, whose historical role had enlisted cunning, deception, and the misuse of her physical charms. This is in the court records, in the court's decision. The court found that if Germans had understood who the historical Esther really was, her name would never have come into general use, since she was, quote, a model neither for Christians nor even less for Germans. And in the course of this ruling, they contrasted the biblical name Esther with the biblical Ruth, not forgetting, of course, to mention that Ruth was a Moabite. And they pointed out that Germans had correctly recognized the name, or they correctly recognized the biblical character of Ruth, quote, for her great loyalty and selfless love, and that unlike the name of Esther, associated with the criminal prostitute of Jewish race, the name Ruth was worthy of German girls. So Ruth was okay, Esther was not. With this and with other arguments, this case was dismissed. Let me add a postscript to the story, which again is about the intensity with which these markers of identity are felt. In 1938, this young woman, this child, was duly registered as was duly registered as Elizabeth against her parents' will. The name Esther was not allowed. Let me see if I have the... Okay. This is the original registration, and then there's a correction on it, which I'm going to speak about. Tragically, Elizabeth died in 1941, but her father did not allow this to be the end of the story. In July 1946, under post-war regulations that rescinded the anti-Semitic legislation of 1938 and much other legislation as well, Elizabeth Esther's father appealed against the court's original ruling, and he was given permission to retrospectively give his deceased daughter the name he wanted, Esther. Okay, and here you see it. Okay, here is the original birth registration. This is an extract from the birth register. Okay, and the child is originally registered as having no name yet. Okay, then down here, the name is registered as Elizabeth. After the court case, the parents had to register her. Okay, and here she is as Elizabeth. And here is the 1946 correction saying that the child's name is posthumously changed in the register from Elizabeth to Esther, what her parents had wanted all along. Well, I don't think I need to add anything more about the power of names and identity and the intimate catastrophes that result when racist despotism is let loose on them. Perhaps the moral of this history is that a certain degree of confusion and instability, the nominal confusion that Bentham deplored, perhaps a modicum of that is good for our liberty. In my next lecture, I'm going to be looking at a different, but in its own way, equally intimate expression of our identity that is also entangled with some intricate legal and social history. That is handwriting and the signature, and with that, I sign off.